name is Carl Pearson. I'm an attorney, and I represent homeowners having problems with their mortgage. And this video is number 35, and it's devoted to something most amazing and most helpful, something everyone has to know about, and soon will. It's a most remarkable decision, a landmark case just decided, and the name of the case is Landmark National Bank versus Kesler, K-E-S-L-E-R, and it was decided on August 28, 2009 by the Supreme Court of Kansas. And this is a very remarkable case, and I want to talk about it because it is of great interest, and I have different categories in which I'm going to talk about this case. So let me tell you, basically, I'm going to discuss this case from the standpoint of the holding itself, what the judges said, what this means to a homeowner having trouble paying his or her mortgage, what this means to homeowners in non-judicial states where there is no foreclosure action, what they can do with this decision, what this means if you have already lost your home through foreclosure. There are things that you should really be looking at now. How this relates to my lottery concept, where I say when you defend a foreclosure action that you may win the lottery, and you may find that you may keep the property in maybe 1 out of 15 or 20 instances. I say it as a lottery because the person suing you doesn't have the right to sue you. And is this decision, this landmark case, going to be followed by any other states? So let me go into this now and say the holding itself. The holding of the Landmark National Bank versus Kesler relates to the Mortgage Electronic Registration Systems, Inc., which is a service that registers mortgages, homeowner mortgages, and facilitates the resale of the mortgage to people who buy interests in the mortgage, so that there's a place that almost half the mortgages recently, or even over half, make use of MERS, and have the mortgage registered there. And MERS has been bringing foreclosure actions as a party because they are the technical owner of the mortgage. The Kansas Supreme Court has held that even though they purport to own the mortgage, they are only a nominee for the real people who own the note. And the fact is that the people who are the owners of the note are the ones who should receive any money on a foreclosure, not MERS. So MERS, they've held, is not a proper party to a lawsuit. It has no standing to bring a lawsuit, and even more importantly, the people who buy their interests through MERS can't use MERS to prove that they own the interest, and therefore title that has gone through MERS is really defective title, and we have all sorts of consequences when a person, a lender or an investor, has title through MERS, and somebody now wants to foreclose a homeowner where MERS is involved. The implications, of course, are also the same insofar as a servicing agent bringing a lawsuit for foreclosure when the servicing agent is not the owner of the note. There's a related issue there that has to be dealt with. So that's the holding, that MERS is not a proper party because it's only a nominee, it's not the owner of the note. You can't take the owner of the mortgage and bring suit because it's not the owner of the mortgage that's entitled to the money, it's the owner of the note. And splitting up the two is defective from a foreclosure standpoint. So what this means to a homeowner having trouble paying his or her mortgage is that if MERS is involved, there is a possibility, and I don't know the extent, but in Kansas I know what the outcome would be. But in other states we'll have to talk about that. But if you have MERS involved in the chain of title or threatening to bring a lawsuit, you might be able to prevail under the same rationale as exists in that landmark decision, that Merce is not a proper party to bring a lawsuit, and anyone that brings a lawsuit against you whose title depends on Merce having given title as part of the chain of title, that's apparently defective under this decision, and the net result could be that the people who intend to bring suit against you for foreclosure may not have the right to do so, and the defense should state that quickly and refer to this landmark decision. So for people who are worried about a foreclosure action, and if Merce is involved, you have maybe additional reasons why you should defend against a foreclosure. In the non-judicial states, you have, once again, you have the people selling out your property under a deed of trust, but if the note is separated from the deed of trust and Merce is involved, you could presumably bring a lawsuit for an injunction to stop them from selling your property because they don't have the right to do so under this decision. What happens if you've already lost your home through foreclosure? You would have an opportunity, if you wanted, to bring a lawsuit for wrongful foreclosure because they didn't have a right to sell your property. So that would be another consequence of this decision. And my lottery concept has always been that when you defend a foreclosure action, you may wind up lucky and find out that the people who sue you don't own either the note or the mortgage. And this is an instance where the owner of the mortgage, as a nominee, is held not to have an interest in suing you, and presumably because they don't also own the note. And as an extension of that, anyone taking title through Merce may have defective title, so that my lottery concept, instead of being maybe 1 out of 15 or 1 out of 20 cases where the homeowner may be able to get rid of the lawsuit because the bank doesn't have the note, the original of the note and mortgage, we now have the possibility that 50% of the foreclosures in America relating to mortgages during the past, I'm guessing now, 3 or 4 years, might be defective. It's a major development to have the possibility of 50% of the recent mortgages possibly being declared invalid because of Merce. So this is a big, big deal for any homeowner that's having trouble with his mortgage. Is this decision going to be followed by other states? And the answer is that I predicted that this would be the result, not knowing of that decision, but I've always maintained that since this decision in Ohio that said that you got to have the original of the note and mortgage, otherwise you're not entitled to sue, well, Merce doesn't own the note, and therefore they don't have a right to sue whether they're a registration system for mortgages or not. They don't own the note. And that was what the effect of that decision is, and it should be law in every state in the country. So I view that this landmark decision will probably be routinely followed, and the consequences are really a major disaster for the banking industry to have possibly 50% of their mortgages, homeowner, residential, recent, declared invalid or possibly be invalid. They have to find the people with a note that have the right to sue you. Because Merce doesn't have that right, and the people that own the note are the ones who should be bringing suit, and they generally don't bring suit, apparently. So anyway, that's this landmark decision. Remember the name, Landmark National Bank versus Kesler, K-E-S-L-E-R. You can find a copy of the decision on internet by searching for 3 words, Landmark, Kesler, Kansas, and you should be able to find copies of that. So if you have any questions, you can give me a call. And here's my name, Carl Person, my website, carlperson.com, and my phone number, 212-307-4444. I look forward to hearing from you. Thank you.